Today we will discuss laws relating to dowry and violence against women. Before we go on to the laws, let us look at some basic concepts. The first basic concept is that of patriarchy. What does it mean? It means the control of men over resources and over all aspects of society compared to women in any given society. Next is the concept of gender division of labor. It means that work that fetches revenue, that fetches a livelihood and earnings, work that is done in the public space mainly, is done by men. And work inside the home is generally done by women. So based on our gender, which is the social construction of men and women in society, based on our gender roles, men perform certain tasks and women perform other tasks. Tasks that men perform are given a lot of credibility in society, and women's work is generally unpaid, unrecognized, and therefore we call it unremunerative labor. This is, to a certain extent, responsible for the problems that women face in everyday life, though economic inequality is not the only reason for subordination and oppression of women in any given society. Apart from gender division and unpaid labor, we come to the next concept, which is gender discrimination and gender inequality. And finally, in order to combat discrimination and inequality, we have many laws in Indian society. Some of them are gender specific and some of them are gender neutral. We will come to that later. Now, what does gender inequality mean? Gender inequality means that resources, opportunities, and livelihood options are different and hierarchical, which is unequal for men and women in any given society. Men and women do not have equal access to rights and opportunities. And this leads us to gender discrimination. So, inequality of power, economic resources, and opportunity leads to discrimination between men and women. What does gender discrimination mean? And before that, I will talk very briefly about an international law which was formulated in year 1979. It is called the Convention on the Elimination of All Forms of Discrimination Against Women. This was an international treaty and India was a signatory to this treaty. By that, India took an obligation upon itself that it will try and lessen all kinds of discrimination against women. What does discrimination against women mean? Any kind of activity, any kind of exclusion or distinction that impairs, that lessens, that restricts, or nullifies the exercise of equal rights of women in any given society. So if we imagine that a society has to be equal and there is discrimination in that society on the basis of our gender, which is whether we are a man or a woman, it means that women are discriminated, right? And this discrimination is there in economic, social, political, civil, or cultural, or any other field. Any kind of discrimination is therefore prohibited by law. But we know that economic inequality, political inequality, and in spite of the laws, and in spite of the power differences, and because of the power differences between men and women in society, women do not have an equal position, though laws often talk about equality. We'll have to map this relationship between egalitarian laws and inegalitarian society or hierarchical society. From discrimination, which is the result of inequality. And this inequality can also be due to certain kinds of cultural norms in any given society. That is why discrimination happens, right? And that is, from that we come to gender-based violence. From inequality, patriarchy, discrimination, social division of labor, gender division of labor, we come to gender-based violence. What does gender-based violence mean? It means that violence, it could be social, cultural, political, physical, psychological, any kind of violence that is targeted towards women and girls because of their gender. Now, what does this mean because of their gender? Say a girl is restricted from going to school. A woman is the victim of sexual violence. And this is happening because, or a girl is trafficked. This is happening primarily because of her gender. If she wasn't a girl, if she wasn't a woman, maybe she wouldn't have been on the receiving end of violence. Gender-based violence is primarily targeted towards women and girls, but it could also be possible that men and boys can be victims of such violence in certain circumstances, though global data is much limited. So we'll have to remember that. Also, in contemporary global order, we talk about persons with non-normative sexualities. We call them non-binary people, trans people, who are also on the receiving end of violence in patriarchy. So gender-based violence could be targeted towards such people with alternative sexualities, non-binary sexualities, and different gender identities as well, and also with young boys. But primarily, it is about women. It is targeted towards women and girls. Now, let's look at the first declaration, one of the most important international declarations that defined what is violence against women. So what does this term violence against women mean? It means any act of gender-based violence that is likely to or results in physical, psychological, sexual harm towards women and girls. That is gender-based violence. What does it include? It includes threats. Not actual violence, but the possibility of violence being inflicted. So threats or coercion or any arbitrary deprivation of liberty with women, that violence may be committed. And we can have many examples of this. Say a woman is out on the street, or she goes to a place and she is threatened that she might become a victim of sexual abuse and violence if she comes out on the road in the middle of the night. Or actual violence that happens to women when she's a victim of, say, domestic violence, or when children face any kind of sexual abuse within the home or outside. So it can be a threat, or it can be an actual violence, or coercion, which is that if you go out of the house, if you do not have a son, then I'm going to throw you out of the house, right? So acts like this, threats like this, are also psychological kinds of violence. So in 1993, we came up with an all-encompassing definition of what violence against women may mean. Then let's look at what are the three kinds of violence, which I already said earlier. It is physical, psychological, sexual, and also economic, which is not there in D4, but it is there in another law in India. And this violence against women can happen in many places, in many areas or sites. What are these places? The first space in which violence against women and girls happen is within the home, in the family, from female feticide, child sexual abuse, preventing the daughter from getting good nutrition or education, to dowry, domestic violence, marital rape. All of this happened within the family. So, physical, sexual, and psychological violence within the family. The next is these three kinds of violence which is happening at the level of the community, right? So, when a woman is called names, when she is witch hunted, or when she is the victim of sexual assault or a rape victim, we call them violence at the level of community. Or maybe she is a deserted woman, or maybe she's a single woman, and then people call her names, right? Verbal abuse, and people think that she's not a good woman. So this is violence at the level of community. And the third is the violence at the level of state. When such violence is happening in the family or in the community, but the state is turning a blind eye. Say a woman comes to the police station to file a complaint against her husband for beating her, and the police people tell her that no, this is family matter, please solve it amongst yourself. Then the state is condoning that violence. Or the state can directly also engage in violence on women. Custodial rapes, etc., are an example of that. Or violence on women in a conflict zone by, say, people in the military would be examples of such kind of violence. Direct violence by the state or indirect violence by the state when they condone such violence happening to women within the family or community. Now, when we talk about violence, we generally use a life cycle model. What does life cycle model mean? It means that if we take a life of a woman from her birth till her natural death, then at every stage, girls and women are on the receiving end of violence. It does not, of course, mean that every girl and every woman will face violence, not at all, but there is always a likelihood that most women might face some kind of violence or another in some stage of their lives. We call this the life cycle model, and we break it up into 3 or 4 parts. The first is pre-birth, birth, and childhood, and what kind of violence do we find there. In India, one of the most significant examples of it would be the sex determination tests that are done to determine the sex of the fetus, and if it is a female fetus, then it is aborted, right? So that when the girl child is not even allowed to be born, and the violence actually starts even before, to the woman who is perhaps threatened that if she gives birth to a daughter, then she will be thrown out of the house, right? Or if she has given birth to a little infant daughter, then she is not well received by her family, she is abandoned, or even if she's in the family, she's not given enough nutrition, etc. So there is violence that happens to the mother in the first place, to the pregnant mother in the first place, then the mother of a daughter, and then, of course, there could be female feticide and also female infanticide. So this is from pre-birth to birth. Over the course of years, in times of childhood, if you look at the period of childhood, then there can be many kinds of violence against girl children and also children in general. That can range from discrimination at the level of the family, prohibition of the daughter from going to school, she has to do a lot of housework, she's not given enough nutrition, all kinds of neglect. Then she can be on the receiving end of physical, sexual, psychological abuse, all of that, or she is trafficked, or she can be put into child labor. Now, child labor, trafficking, child sexual abuse, of course, can also happen to boys. Let's also recognize that. But women do face, or girls do face this more that is also something that we need to accept. So that is the first stage of violence. The second stage of violence we see is from adolescence to adulthood. Say a daughter is forcibly married off at a very young age. Her education is stopped. Once she has gone to her in-laws, there is no way that she can come back to her parents' home if there is violence in the family or if something wrong happens in her in-laws' place. And then marriage is a huge space in which a lot of violence on women in India happen. For example, dowry and domestic violence. Of course, in adulthood, in both in adolescence and adulthood, we also find various kinds of sexual violence that happen to women and girls. So this is the period of what we call adolescence to adulthood. And finally, we come to old age, where with a combination of gender and age, we see, because of this double inequality, elderly women are on the receiving end of a lot of violence, like neglect, throwing them away from their own home, forcibly taking away their property, their children don't look after them, she is completely abandoned, or she can also be on the receiving end of various kinds of violent crimes. We have seen a lot of murders, etc., of elderly people in India. So this is also a kind of violence. Interestingly, we have laws for each one of these acts of violence. From pre-birth, for example, sex determination test is banned by the PCPNDT Act, the Preconception and Prenatal Diagnostic Techniques Prevention Act, child labor, child trafficking, right to education. We have laws relating to everything. So there is no dearth of laws in India as far as violence against women and girls is concerned, but there is a gap between having a law on paper and the implementation of the same. Now, where are these laws? Where do we find these laws? One major space in which we find laws that prohibit violence against women is in the Indian Penal Code, which is a criminal manual that clearly lays down acts that constitute offenses or crimes and the punishment for the same. And if we look at criminal law, the Indian Penal Code, we see that it is roughly, we can say, divided into two parts. One are gender-neutral provisions of the law. For example, culpable homicide, murder, punishment for murder, abetment for suicide, wrongful confinement in secret, criminal force or assault. These are all gender-neutral provisions. They apply to both men and women. And in the IPC, there are also gender-specific provisions, which is laws that prohibit certain kinds of acts of violence against women, certain actions against women. For example, molestation, we call them outraging of modesty, which is under Section 354 of the Indian Penal Code. There are laws relating to rape and prohibition of rape, 509, obscene gestures, and many other offenses related to marriage. For example, dowry, dowry death, cruelty, all of this are gender specific, which is a woman can claim rights under this law as a complainant. She is the victim, and in these laws, the man cannot claim victimhood. So these are gender-specific offenses. Gender-neutral offenses like abetment to suicide is often used in cases of dowry death, where we say that the in-laws created such conditions that the woman was sort of pushed to commit suicide, and this is called abetment. So there are wrongful confinement in secret. A woman is forcibly confined and then she's trafficked, right? So these are examples where they are gender neutral provisions, but they are in many cases applicable to women specific criminal circumstances. Okay. Now let us come to the specific provision of dowry. We all know that dowry is not only an offense in India, it is a social evil. It is a disease, we can say. And there are laws that are there to combat dowry. And again, there might be a lot of discrepancy between the law on paper and what is actually happening, right? That in spite of the law, dowry is given and taken by men in our society. And we see that there are also dowry death or certain other cruelty on the married woman because of dowry. That is also something that happens. Now, let us look at one specific kind of offense against women in India. And we are talking about dowry, which is an offense against women and mostly married women in India. Now, we all know that dowry and giving and taking of it is an offense, but it still continues as a social evil. We will now quickly look at the changes in the dowry prohibition laws in India. What is dowry? It is certain things which could be goods, like things in kind, or cash, which is given in connection to marriage. We think that dowry is primarily a social practice amongst Hindus, but we know that it is a practice that is also there in other communities as well. So, what are the legislations relating to dowry? We know that it is prohibited by law. Now, the social reform movements in the 19th century tried to bring about changes in the status of women during that time. And we know about several changes that social reformers ushered in, initiated during the colonial period. So in the British period, we know of Sati Abolition Act, we know of the Widow Remarriage Act, and the first instances of engaging with dowry as a social evil also started during the colonial period. Now, one of these first legislation was in 1939, and it was called the Sindh Leti Deti Act. It was in the state of Sindh in undivided India. Leti Deti, which means taking and giving, right? So taking and giving of dowry was prohibited, not prohibited, it was, they were trying to restrict the giving and taking of dowry under this Sindh Leti Deti Act of 1939. Then right after independence, we also had provisions called the Bihar Dowry Restraint Act of 1950 and the Andhra Dowry Prohibition Act of 1958. These were all, as you understand, social legislations, and they were restricted to state. So they were state legislations. And finally, in 1961, we have the Dowry Prohibition Act, which became a national legislation, which means it is applicable all over India except Jammu and Kashmir at that point of time. Now, 1961 Dowry Prohibition Act prohibited the giving and taking of goods or cash in connection to marriage by either party. Now, this is interesting because the law is gender neutral. It says no party can give this in marriage. But we know that in practice, it is always the bride's family that gives kind and cash to the groom's family in connection or in consideration of marriage. So, 1961 Act, in spite of its gender neutral flavor, it worked more gender specifically. Now, apart from the Dowry Prohibition Act of 1961, there were also other amendments that came in, and I'll come to that just in a while. Now, the Dowry Prohibition Act of 1961 had this idea that dowry is given or taken in consideration of marriage. And we know of a lot of films, a lot of literature which says that when the groom's family comes and enough money is, or enough things are not given to them, which was agreed upon, and they say that we will not marry this girl, right? So it is in consideration for marriage. But we gradually understood that dowry is not only given or taken in consideration that the man will marry the woman, but in connection to marriage. The dowry giving and taking keeps on continuing, right? Even after years of marriage. So there was an amendment, that is the law. There were changes brought about in the law, certain provisions. And from consideration of marriage, the term was in connection to marriage, because it keeps on happening even after years of marriage. Now, these changes, these amendments came in and around the 1980s, 1984, 1986, in the 80s. Why? Because in 1980s, the autonomous women's movement in India became very, very strong, which is autonomous women's movement meant that there were several organizations that grew in India which were not affiliated to any political party as such, but they were fighting for rights of women. And these organizations tried to raise awareness about the social evil of dowry and bring about changes in the Act. And this 1961, from consideration of marriage to connection to marriage, came about in this period. The 1961 Dowry Prohibition Act underwent amendments in the 1980s, in 1984 and 1986, and in latest one in 2018. And why were these changes ushered in the 1980s? Because the autonomous women's movement in India was very strong. What was the autonomous women's movement? A number of organizations which was on women's rights emerged at that point of time, and they were not attached to any political party. And these women's rights organizations drew attention to the social evil of dowry, and amendments to the law from consideration of marriage to connection in marriage happened at that point of time. But apart from the giving and taking of dowry, women's movements drew attention that women face violence in their matrimonial homes not only for dowry, but for several other reasons. For example, that maybe she doesn't cook well, maybe she does not have a child, maybe she hasn't given birth to a male child, maybe she's dark, maybe she comes from a poor family. So, women face physical and psychological harm in their matrimonial home, not only for dowry, but for several other reasons. And that is why we see a new section being inserted in the Indian Penal Code, which was section 498A, which is cruelty on married women. And the law prohibits physical or psychological cruelty on married women, irrespective of whether there is a dowry claim or not. So these changes also happened. Interestingly, the law of dowry, which said giving and taking of, cash or kind is prohibited by law, gifts were outside the purview. And we know that in the Hindu rites of Kanyadan and Varadakshina, which is that you give the groom certain gifts, Varadakshina, or you give the daughter as a dan, as, giving away of the daughter. These are practices of marriage, right, of Hindu marriage. And it is from there that the idea of dowry came in. Originally, dowry was tridhan, which is gifts or jewelry or money that is given to a daughter during her marriage, because earlier daughters were not entitled to property. And so parents of more or less middle and upper middle class well-to-do families gave Stridhan to their daughter, which it is the property of women, right? Of married women. But over a course of time, this combination of Stridhan and Varadakshina became dowry, and it became coercive. Interestingly, anything that is given as a gift in marriage is outside the purview of dowry. So one can gift a huge car or a flat or a bike or give lakhs and lakhs of rupees to the groom and say this is gift. It is not a dowry. And therefore it will be outside the purview of law because there is no upper limit that more than this is dowry, less than this is not gift. Because in India, it's a very economically divided society. So what is a lot of money to a poor family will be very little money to a rich family. So there is no minimum or maximum set. So actually, dowry continues, but through the back door as gifts. Apart from the provision of dowry, giving and taking of dowry and cruelty, the last thing that we need to discuss are dowry death. What is dowry death? We see that a lot of women, young women, died out of accidents, stove bursts. A lot of these cases came out in the 1980s, and there was a pattern that was emerging. All of these girls who died were recently married. They did not have children or had very little children. They were all economically dependent on their husbands, and they apparently all died out of stove burst accidents. And the women's movement started finding it out from newspapers that these were all deaths because of dowry. They actually burnt the woman and posed it as an accident. And there was, from this pattern, the Law Commission of India actually identified this pattern and said, correct, the women's movement correctly identified. And they said that let's push for a new provision again in the Indian Penal Code, and that was a provision on dowry death. 304B of the Indian Penal Code is dowry death, that if a woman is dying in suspicious circumstances within 7 years of marriage, and there seems to be that there was a demand for dowry, then it would be assumed by law that she was killed for dowry. And the burden of proof will now shift to the husband and in-laws to prove that they did not kill the woman, right? So this was a major shift in the law that had happened. So this was dowry death. And finally, we see that in 2018, again a shift in the Dowry Prohibition Act happened, and the last amendment was from consideration to connection, which happened in the 80s. And in 2018, we see that dowry, the definition was expanded to mean things that are given before the marriage, at the time of the marriage, and after the marriage, in all spaces, right? In that entire duration, not only during marriage, before and after. And all of this is understood as dowry in an attempt to curb this social evil of dowry. But the problem remains that unless we willingly refuse to get our daughters married to men who claim dowry, or daughters or girls refuse to marry men who claim dowry, the problem is not going to go only with law. That is not possible. It is time for women and men to resist this social evil and say that in marriage, it will be a marriage of hearts, of equal parties, and it is not for cash or kind or any other thing. Marriage is amongst equals, and men and women have to realize this, and law will just be able to help to a certain extent. But as I said, gifts are outside the purview of law. So it will only be able to help to a certain extent. It is up to us that we resist this practice and we really push for an egalitarian world for women and men in marriage or outside marriage as well. So that was our discussion on dowry and a brief discussion on laws relating to violence against women in India.